Precedent in decentralized law. None have right to rule. The only right we have in affecting the lives of others is providing fair decisions for dispute and conflict resolution as it affects upholding the non-aggression standard. None are endowed with power from on high or the depths below. Neither the stars, nor comets, nor planets, nor moons, nor bloodlines, nor ceremonies, nor diplomas, nor ancestry, nor hats, nor outfits, nor bank accounts, nor otherwise can give right for an ape to rule another. This authority is instead, fiction, and fiction only, and with it, also, is its decree, and specifically important in this topic is the decree that one past judgment shall affect judgments into the future. The decree that a judgment in the land will affect future judgments, that a judgment made by one appointed judge will be so fair and worthwhile that it will be applied to lives far into the future, is unacceptable in decentralized law. This decree is an appeal to authority, and as we have established, authority is fiction, unless it is authority over oneself and their property. In centralized law, there are statutes written by the thousands, even millions, and by the hands of lawmakers who are alleged to be representing the people due to having won election. These laws are added upon year after year, often creating more and more restriction and devastation to millions of lives ruled by central planners. Because there is no logical or otherwise valid basis for humans to rule other humans, hominoid primates ruling their own kind, there must not be centralized law. Morality creates lasting quality of life, and disregard for morality, or, in other words, disregard for what has logical validity in making life of objectively increased quality universally, is what maintains the catastrophic resetting of human advancement and civilization, the fall of nations, and collapse of peace. Lasting peace and prosperity is not brought through disregard for morality, that which is valid logically for bringing objective, measurable, duplicatable and observable quality increase to lives universally. The establishment of precedent, if not organic or naturally evolving, is only an appeal to authority, which authority is only the pretense of law monopolies. In decentralized law, precedent must form organically, in the way that language forms the precedent of what words mean. Because everything outside the non-aggression principle is much more vulnerable to scrutiny of basis, it cannot be sustained in such an environment of competition of law. For example, use of free speech, outside of verbal threats to inflict harm, cannot be affected by organically formed precedent, because cases cannot be won in favor of limiting free speech in decentralized law. There are simply too many checks and balances on those who would judge absurdly. Scrutiny from any onlooker could rise, and basis would have to be proven. The widespread use of non-aggression as a standard for law would form organically, and speedily, as its basis is universal and valid, compared to most other standards by which to conduct law. Non-aggression has long been the only basis in law that has not caused rebellion and riot through its use. In such an environment, none could impose precedent to be honored in future cases, else they would be claiming to be an authority from which others must take orders. Swifter processing of disputes can be done by referencing what has been done before, in cases with time and energy dedicated to more precise examination and philosophical dissecting of the situation, but this is not precedent by force, only precedent by convention. Some of those conventional precedents may even become established as agreements between firms for simplification of law procedure. However, most likely will be that certain crimes against others will fall into a limited array of options that are acceptable, meaning that there would be many options in how to handle resolution of a dispute in which others would not be in opposition. Choosing wisely in how to proceed in decentralized law is essential for preventing others from challenging the decision, and thereby also casting doubt on competence and reputation. It cannot be that there is force on others to use established paths in deciding fairly for the outcome of those needing the services of dispute resolution. By imposing or insisting on one path to a resolution is to strive for centralization of law, which is destructive to human quality of life. Monopolization of any service is decline in service quality, but especially harmful is monopolization of law services, which gravely affects all other industries. Nationalism is the geographical monopolization of the industry of law. Decentralized law is separate from geographical boundaries. Service providers may choose without asking permission in which areas they will serve. Any given region may have 100 or more options that in some way are services in the industry of law, though such service providers may differ depending on the area. Precedent by convention, just the mere convenience of the decision process having been thoroughly done before, is precedent enough, and even that can be easily challenged if there is enough desire by onlookers to raise question for the way things have been done in the past. No path is to be deemed so correct that it is to be imposed far and wide by decree. True democracy is decentralized law, but unlike democracy of political inventions, this democracy inherently must align with non-aggression principle, or it will cause suffering of the law industry, which suffering would only bring economic hardship to those working in the law industry. Of course, suffering also would be on the part of paying customers, an unacceptable outcome in an environment of law competition and open weapons markets. Through and through, there is but one way to proceed when it comes to law, and this is decentralization. It is the latent nature of every last ape to abuse power over others. Power through imposing precedent is great, as it imposes great limit on the ability to question what has been laid forth already, in addition to the obvious fact of there being powerful monopoly of law wherever there is imposed precedent. Decentralized law bypasses every last one of these ongoing issues in the monopolized law industries of nations throughout the world. Nationalism will fade as decentralized law gains. Borders and authority will grow to be relics widely viewed as mythology, and the many delusions surrounding this religion of government and nationalism will give way to practical and reasoned progress toward complete decentralization and its ability to sustain lasting peace and prosperity.